Ladies and gentlemen, dear colleagues, thank you for inviting us to present this video within the framework of the conference on the concept of family within the legal order of the EU. My name is Marlene Brosch, and together with my colleague Cristina Mariottini, we will present the main outcomes of our conference paper on the European model of couple within the dissolution of marriage. The aim of our analysis was to identify, within the general theme of the project, whether a European model of couple exists within EU law under the light of the dissolution of marriage. The starting point of this analysis are the EU private international law instruments for family matters, the Free Movement Directive, as well as recent case law of the Court of Justice of the European Union and the European Court of Human Rights. Specifically, our analysis was threefold. First, we analyzed whether substantive components can be deduced from the current EU framework for the change of legal status. Second, we examined the characterization of same-sex marriages in the context of the dissolution of marriage. And third, to provide a comprehensive understanding of the notion of couple, we addressed the dissolution of other types of stable relationships beyond marriage. Notably, we identified certain cornerstones in the uniform procedural rules and applicable law rules of the EU regulations in family matters. These instruments enshrine several substantive goals that shape a certain EU model of couple with regard to the dissolution of marriage. These cornerstones are, first of all, party autonomy, as well as the principle of favor divorcii, which means that access to divorce is facilitated and the cross-border recognition of divorce decrees guaranteed. Furthermore, the spouses should make informed choices, which means that choice of law agreements are only reasonable and appropriate after having sought information and legal advice. Another important building block is the substantive principle of gender equality, enshrined in Article 10 Rome III Regulation, to set aside the applicable law if it limits access to divorce or separation on the basis of gender. The spouse's autonomy and consensus on the dissolution of marriage is also emphasized by the recent reform of the Brussels IIb regulation, which facilitates the cross-border recognition of certain prior. Finally, it should be noted that factual relationships, which are legally recognized in many member states, as well as by the Free Movement Directive, may have similar consequences as marriage with regard to their dissolution. Consequently, the EU regulations on the dissolution of marriage should also comprise the effects of such factual relationships and should therefore be open to the diversity of family forms within the model of couple.
The EU private international law instruments in family matters lack a uniform definition of marriage, such definition being left to national laws. Against this background, the characterization and treatment of same-sex marriage in the context of dissolution of marriage is at the junction of a fragmented normative scenario. From such scenario, a series of open questions arise. As it pertains to jurisdiction, the question whether the Brussels IIb regulation and its recast apply to same-sex marriages is a pending issue. While a more conservative interpretation of the regulations relies on the assumption that same-sex marriages were not permitted at the time the Brussels IIb regulation was drafted to maintain that such marriages do not fall in the scope of the regulation, a more contextually sound interpretation supports the inclusion of such marriages in the scope of both regulations on the grounds that such marriages are valid in the state and that the recast regulation employs the term spouse as opposed to husband and wife. To add further complexity to the cross-border treatment of the dissolution of same-sex marriages and the EU notion of couple, the law applicable to divorce is not governed by uniform conflict of law rules throughout the European Union. In fact, the adoption of the Rome III regulation has implemented enhanced cooperation in the law applicable to divorce and legal separation. And at present, 17 EU member states participate in this enhanced cooperation. Furthermore, the fact that Article 13 of the Rome III regulation defers the question of the validity of same-sex marriage to the substantive law of the foreign state contributes to further fragmenting the EU notion of couple and its treatment by permitting a court to depart in a unilateral and discretionary manner from the application of the regulation to same-sex divorce. Against this backdrop, and certainly on a brighter note, the hermeneutics of the Court of Justice vis-à-vis the principle of free movement and EU citizenship have supplied some meaningful assistance in laying the foundations for, inter alia, the common notion of marriage. On a final note, similarly to what occurs with respect to the term marriage, what constitutes a civil union or a registered partnership is defined in accordance with national law. Registered partnerships in particular are considered equivalent or comparable to marriage in some EU member states, but not in others. In this context, two phenomena affect the shaping of an EU model of couple and impact its treatment in the cross-border context. These phenomena take form in the possible default conversion of, on the one hand, a same-sex registered partnership into a same-sex marriage, as is the case with Belgium and Scotland, and on the other hand, of a same-sex marriage into a same-sex registered partnership, as is the case with Italy. Overall, the default upgrading and downgrading of couple relationships introduces an additional variation and an element of ambiguity in the shaping of an EU model of couple, and are not without risk for the couple in the cross-border setting, since they affect the regime that is to govern the dissolution of the relationship. Thank you for your attention.